Honor, the defendant has established through her own behavior that she cannot be trusted to obey a court order or to appear at future court hearings. The state believes that bail should be confirmed where it is. We have no confidence that the defendant will stay in the area and appear for future hearings should she be released.
The prosecutor has gone through a litany of allegations for which she is not facing any sort of criminal charges whatsoever, and not criminal charges in this case. Those should not be considered by the court for purposes of this case and setting bond pursuant to Idaho, the factors listed in Idaho Criminal Rule 46. We would ask that you grant the defendant's request and set bail as requested in this matter.
The court has listened carefully to the argument of both the state and the defense. The court has reviewed in detail and in full Rule 46 of the Idaho Criminal Rules. The court has also reviewed the Idaho Bail Act, Title 19, Chapter 29, specifically under 1929-04. It designates that the court may release a person on his own recognizance or set an amount of bail, and may impose any conditions of release. In making these determinations, the court shall consider the following objectives. Number 1, ensuring the appearance of the defendant. Number 2, ensuring the integrity of the court process, including the right of the defendant to bail as constitutionally provided. Number 3, ensuring the protection of victims and witnesses. And number 4, ensuring public safety. The court has taken all 4 of those factors into consideration, as well as all 10 factors under subsection C under the Idaho Criminal Rules 46. And based upon the argument that I've heard here today, the court is going to reduce bail. I'm going to reduce bail to the amount of $1 million. I recognize all of the factors that have been looked at here. One specific thing that the court notes in setting such a high bail amount is that there is a pending court order, and to my knowledge there has been nothing set forth regarding obedience to that court order pertaining to lining the court out with information on where the 2 children are at the Department of Health and Welfare or at the Rexburg Police Department. So with that, bail will be set at $1 million. If bail is posted, there will also be the following conditions that are ordered. Number 1, there will need to be a waiver of extradition signed from any and all jurisdictions to be brought back here before the court. Number 2, I'm going to require that Ms. Daybell not leave Bonneville, Jefferson, Madison, and Fremont counties. If she were to leave any of those counties while this case is pending without permission or authorization from the court, that would be a violation of the terms of bond and release. I'm also going to order that there be an ankle monitor that is placed on the defendant. That will need to be all lined out before she's eligible to bail out. It will be monitoring 24 hours a day, 7 days a week as to where the defendant is. And then lastly, I'm going to order as a term of any release or bail that the defendant appear for all court appearances, that she maintain contact with her counsel, and that she abide by all the laws of this state, this country, this county, and this city.